consideration. Actually, if you want to define, we can call this as something in return. Okay. You have to focus on both the words. One is return and another one is something. When we give focus for the first word return, it means first it is your duty to perform, then get the benefits. Okay, which means if you are liable for something, if it is there is your performance to be done first, do that first. Then get the benefits from the contract. And what that benefits could be, it can be anything. That's what something is. It can be of anything, any nature, but it should be what? Lawful and legal. You should not forget these two words, return and something. Okay. Example, if I talk about gift, I'll be giving something out of love and affection, but I'll not accept anything, right? I'll not be I'll not be expecting anything that if I give you one pen as a gift, what you will do for me. No, I'll not expect in that way, right? So gift is not a consideration. Gift will not come under the contract. Let me go for the example, the usual example which I discuss. I own a car, so I'm the owner of the car. Okay. The contract is about, the subject matter is about selling the car. Who's starting? Who's offering this one? Let us assume that it starts from Y. So Y starts the offer saying that he or she wants to sell the car to X. Am I right? So usually we'll discuss this one, right? Y is the owner of the car offering to X saying, will you buy my car for 20 lakhs? To whom? X. Till the earlier topic, we were discussing that Y will be called as the offerer and X will be called as the offering. And now, once X has accepted, this becomes a contract. Okay. And please try to remember all the essentials of a contract. What's the very first point? As we discussed, the 10 points. What's the very first point for a contract to be a valid one? Minimum two parties. So that two parties, one party will be the offerer and another party will be the acceptor, and they should have the consensus addendum. Probably, in my assumption, let me go that I have only one car in my own name. So I'm going to sell that car only. Okay. Next heading is on consideration. Before going for consideration, let me take away from this point of view where I'll go from the promise side. Okay. First, let me discuss on Y side. Tell me the promise of Y. What Y is promising? Yes, please join with me. What is Y is promising? To sell his car. Okay. To whom? X. Okay. Now let me go for X's point of view. What is the promise of X? Yes, please join. What is the promise of X? Promise of X. He will give 20 lakhs to whom? Y. Okay. Now come for the definition. Something in return. Let me focus on the word return. Okay. Please understand, you should give something. It's a duty, it's a liability to perform something. Then only can expect for the benefits to be returned. Now come here for the first point of view, Y's point of view. What is the liability or duty of the Y? What is the promise I'm asking? What is the promise of Y? What is the duty of Y? To give the car. If he gives the car, what he will get? 20 lakhs. Now come for X point of view. What is the liability of X? That is, what is the promise of X? To give 20 lakhs. If he gives 20 lakhs, he will get the benefits. What is the benefits he'll get? Car. If you have a keen look, for one person, for example, Y, giving the car is the promise, getting 20 lakhs is the consideration, means for the other party is just the reverse. For X, giving 20 lakhs is the promise, which is the consideration for Y, and getting car is the benefit, which is a promise of Y. So one person's promise will be another person's consideration. If we say something in return, we are not talking about one party, we are talking about both the parties involved in the contract. So usually we say consideration is nothing but this is one point something in return. We may be saying it's nothing but exchange of promises, right? My promise is your consideration, your promise is my consideration. So it's nothing but exchange of promises, or we highlight this phrase to get this 20 lakhs. Please come here in wise point of view. To get this 20 lakhs, what he is paying. See, paying means need not be in terms of money. Please understand. If you are selling or buying, if only that is the concept, we'll talk about money. If it is selling and buying means, I'm not talking about selling and buying, I'm talking about offering and accepting. My example holds buying and selling. Don't go for the example, go for the Indian Contract Act. Indian Contract Act says offer and acceptance is the two things will follow here. It's not about selling or buying, it can be of anything. Yes, tell me. Why is giving 20 lakhs? Sorry. Why is giving car? Why is giving car? Okay. What he will get? 20 lakhs. Okay. Please understand. Let me go for X, then I'll come for Y. X is giving 20 lakhs and buying a car. Car is the promise of Y. Am I right? Please follow. Car is the promise of Y. To buy this promise, what X is paying? To buy Y's promise, so that is, what's the promise of Y? Car, selling of car. To buy Y's promise, what is X giving? What is the price? What is the price he is paying? 20 lakhs. So we usually say consideration is nothing but a price of buying a promise. Okay. Now try to understand the same way for Y's point of view. To buy 20 lakhs, okay, this line seems to be like somewhat funny. How am I going to buy 20 lakhs? Okay, okay. I'm going to go for a foreign trip. To buy the foreign currency, what you have to pay? 20 lakhs? Please try to understand. Don't think this as money and this as car. It's a promise. To buy this 20 lakhs promise, okay, 20 lakhs promise of whom? This is a promise of X. To buy this promise from X, whether it's 20 lakhs or whatever it is, to buy this promise from X, what is Y paying? Car. So car becomes the price for the promise of X. He pays he pays car to buy the 20 lakhs from X. Is it okay? This is what considerations. If you want to make a note of anything, go from single material. Consideration. The legal maxim is quid pro quo. This is a legal maxim in Latin language. In English, it means something in return. It means it can be anything. Please remember, it need not be money. It can be anything. Okay. First point. Second point is the price for which a promise is bought. We have discussed. Third one is a sign and symbol of every contract. If we say there is no consideration in a contract, definitely this is not going to be a what? Contract at all. Okay. For a contract to be a valid one, definitely it should be lawful. What are the three types of agreement we have? Already we have discussed this. It's like old topic for us. What are the three? Social, void, and legal. We are discussing about the legal agreement because we are discussing about contracts. If I give a car as a gift to you, it becomes social. If I steal a car and give it to you with consideration, it becomes void. Why? The person, if I am the owner of the car, means only I have the right to sell the car. Right? Myself, why? I'm selling the car to you means obviously what you think. Is this my car? Or you doubt? Ma'am, நம்ப முடியாது. What you feel, what your intuition says. Yes, this is ma'am's car. Okay, I'll buy it. And we see the market rate is also is equal. Second-hand car market rate is also is equal. Okay, we'll buy it from ma'am itself. But at single point of time, if you doubt me, really this is ma'am's car? Nambi வாங்கலாமா? If this is the problem, then you should not buy. Law says this is not a contract. Okay. If you're aware or if you find that anything is not right, then at least you should raise question. Ma'am, can I believe that? Is this your car? நான் உங்களை கொஞ்சம் தப்பா நினைப்பேன். That's okay. Please try to understand who can sell the car. Only the owner can sell the car. Okay, let me continue. So when we say there is no consideration, then it can never be a contract. Okay, it can never be a contract. So this consideration becomes the sign and symbol of every contract. Fourth, there's nothing but exchange of promises, or nothing but promises means what? I have to perform something. That's what you call as promise. So exchange of promises or performance with parties. Fifth point, please try to understand consideration should be on both the parties, for both the parties. Benefits. Consideration is nothing but benefit should be for both the parties, not for a single party. So if there is any single promise, which means is it enforceable? No, because consideration is there only for one party, it cannot be enforceable. All these 5 or 6 points will be needed for. And ultimately, when we say it's consideration, it should be giving some benefits to the promiser or detriment to the promisee, which means what? Promisee has to give something to get something, right? See, if you take over the promiser point of view, if I am the promiser, I am promising, which means I am losing something and opting for a benefit. Promisee point of view, you have to lose something to get your benefits, right? See, that's about equality, right? And it can be both also. So that's about this point. This case you can just refer later. I'm not going line by line. So consideration definition is done for. Next we'll go for next heading, legal rules. Actually, what are the things we are going to discuss here? We'll just go for a small blueprint. We'll discuss on definition of consideration, what we have discussed here. Then we'll say that consideration is not just consideration. We have to say it's lawful. So we have to go for the legal rules for a consideration to be a lawful one. Second one. And third and fourth heading are somewhat special cases falling under exception cases. Exception. Because when we say, first one, that is the third point, when we say no consideration, what the general law says, no contract. Please try to understand. This is a general law. If you don't talk about consideration, don't say it's a contract. It's not a contract. But there are some exception cases, even though there is no consideration, it's going to be a contract. So this will discuss in the third heading. Fourth heading, whether a stranger to a party, to a contract can sue. Whom do you call a stranger? Actual law says cannot sue. This is the general law. Who is a stranger? In our example, we are talking about X and Y. These are the two parties in the contract. What Y will give 20 car. What he will get 20 lakhs. What X will give 20 lakhs. He will get car. We are the complete two parties in this contract. There may be some other party Z or A or any parties. We'll call these parties as stranger to a contract, which means third party, they don't have any link with us, either X or either Y. In case, just imagine, I am getting 20 lakhs from you, I am not giving the car. Immediately your friend beside you will be saying, "Appo sonna ma'am and amma thank you." Okay. Or the other way, I gave you the car, you did not give 20 lakhs. See, anything can happen, right? Anything can happen. In this case, if I'm not giving the car, what is your right? It's a legal agreement. You can file a case on me. Okay. If you have given 20 lakhs, I'm not giving you the car. What you can do? You can file a case. The other way is also true. Okay. What? You have given 20 lakhs and you're not getting the car, you can file a case. What is the other way? Sorry, suddenly out of mind. I have given the car, you have not given the 20 lakhs. So what I can do? I can file a case on you. Okay. But what is the role of Z or A or B here? You say, your ex, right? You say, ma'am, I bought the car from you. I promise that I'll give 20 lakhs. But I'm buying this car to give to my brother or sister or dad or mom. He seems to be very reasonable. Immediately, your dad, Mr. Z, he comes and files a suit on you. Okay? This cannot be done. Even though you're going to gift up. That's your thing. That's your personal. What the law says, who are the two parties here? X and Y. If any other party involves, any other third party, whom do we call a stranger? Third party is what? Other than the two parties in the contract, other parties are what? Third party. Stranger. Then this stranger cannot sue on the other party. So general law is stranger to a contract cannot sue, but still access, there are some exception cases. Is it okay? So this is third and fourth case. It's special category case where we're discussing on the exception category. First one, complete definition. Definition is quite clear. Quid pro quo, something in return. That's it. But along with that, we have added some lines for support our cases. Okay. Shall we go for the second one? When we say a consideration is valid. Yes, please join with me. First point, it should be definitely there should be a consideration to support every contract. It becomes an essential. It's one of the essential, right? Out of the 10, this is one of the essential. Please make a note of the second one. It may move the desire of the promiser, may move from the promisee, please add a E here, may move from the promisee or the third person. Let me go for the same example. Y to X, the same subject matter car, but I don't know how much the amount to be fixed. I don't know how much the car may be worth for. Actually, I am giving this car to get a consideration, to get a benefit, right? So I should fix what benefit I need. I, in the sense, I'm talking this in the status of a promiser. He comes in the first order. It comes like a hierarchy. If Y is not fixing, see, I'm not a car mechanic at all. I know to ride a car and I have a car in my own name. I know to drive it. And the car is in my name. But I need not know the car mechanism at all, right? How far the worth of the engine will be, how the what the status of the engine or whatever it is. So what I say is, I don't know about the mechanism part. You tell me the rate. Yes, it can be done. First, who has the right? Promiser. If promiser is not willing or not able to give the price, then what will be the right of? It will be passed to X. Who's X here? Promisee. Please make a note. Promisee. Okay. If, see, you also need not have the knowledge of this mechanism, right? So what you're saying, ma'am, I also don't know, ma'am. So what we'll do here is we'll go for a mechanic. We'll go for a mechanic who is completely a third party. If this mechanic is not again mentioning any price, then we'll go for the reasonable price. This is the order. Okay, now let me go over here. See, from whom the consideration has to go. It is the desire of the promiser in order. Okay, may move from the promisee or third person at last. If there is no other go means, we can fix at a reasonable price. Clear? Let me go for the third one. The consideration, which is nothing but a promise, which is nothing but a performance, can be executed in past or present or future. Can you go for the examples, Paul? I asked you to go through the examples for today's session. Can you go for a fast reading? Make it faster. Actually, we have 4 examples. Here we say executed and executory means partly executed and partly executed, and completely executed or completely executed. Okay. So let me go for the first example. A pays 5,000 rupees to B and B promises to deliver to him a certain quantity of wheat when within a month. In this case, A pays the amount, whereas B merely makes a promise. He is not giving the wheat. He is just giving a promise. Therefore, the consideration paid by A is executed, whereas the consideration paid by B is just promise, not paid. It's just promise, not performed. We call this as executed. B. X renders a service for Y on Y's desire. After a couple of days, Y promises X to compensate him for the services rendered by him. Past consideration, something done in the past. And you want to make it as a contract today. Past consideration. C. Cash sales. Present consideration. You go to the shop, buy a pet, and come back. You pay the money and come back. It's over. It's all happening immediately. So it's present consideration. D. X promises to deliver his moped to Y after a month. Please make a note. After a month. Y promises to pay the price after 2 days of the delivery. So everything is going to happen in the future only. So you call this as future consideration. Is it okay? Shall I go for the fourth point? Fourth point, it need not be adequate, but court may consider for free concern. Why? Myself, I am giving this car for just 2 lakhs. It's actually worth 20 lakhs. You go check the second-hand car dealers or you go check in the OLX, everything it says 80 to 20 lakhs. Okay. If you're giving for 15 lakhs is also fine. But what I'm doing here, I'm just giving for 2 lakhs. And you're very happily buying the car. See, my intention is not to cheat you. Your intention is to buy the car from me. Just we bought it. See, what the law says consideration is something in return. What I get, something, even if it's 1 rupee, okay, fine. Okay, please try to understand. In case you gave me 2 lakhs and I have to deliver the car which I have not delivered, you directly go to the court of law because this is a valid contract. You directly go to the court of law, which means you file a suit. First question, the contract will be checked by the judges whether this car valid for this worth for 2 lakhs. Actually, they'll see the car model, etc. They see that it is around 20 lakhs. Immediately, this one will be asked. Did you coerce why? Did you threaten why? Did you take a gun at her home and ask to sign the document to give this 2 lakhs? No. You have to prove. See, court will consider whether this is a free consent. Whether it's Y's mistake or X mistake, the first question asked in the court of law will be whether this is a consent free and genuine or not. Okay. So that's about the fourth point, which means what? It need not be adequate, but court will consider for free consent. Okay. That's the fourth point. Fifth point, it can be of doing a positive act or a negative act also. So this we have followed from offer, just carrying over the same. It should be real because there should be possibility of performance. It should not be something illusionary. Seventh one, let me go for the example. A promised to pay the vakil an additional sum if the suit is successful. What do you mean by this suit is successful? See, you have a problem and that is gone to the court of law for some case proceedings. You need an advocate. You go and see an advocate. You consult an advocate. Immediately you say that I appoint you, sir, but if the case is successful, I give extra amount. Why you need to see a professional person to make this case successful? Right. But what you are adding here, I will pay you additional sum. This additional sum is not legally he has to bound for. See the wordings? Not be something which the promisor is already legally or contractually bound to do. If you refer a vakil, it is his duty to make the case successful. If the case is not in favor, means it's not his problem. Okay. You ask the vakil to take over a case means he will take the complete proper mere steps to make the case successful. In case the judgment is not in favor of you, it's not the vakil's fault. Okay, because both the sides they have two persons, right? Two vakils are there. But what the act says, it is his duty to make it successful, which means what? He has already legally and contractually bound to do that. Okay, he's already legally and contractually bound to do that. You need not fix the additional sum. So in case in future this vakil is taking over the case and it becomes successful, does A need to pay the remaining sum? Need not. In case the vakil files a case on A, will vakil win? No, because it's an additional sum which is not the contract. Okay, that's about the seventh point. Eighth point is simple. It should not be illegal, immoral, or opposed to public policy. Make a note of this line where we'll be discussing this on lawful object. See, at one point of time, you cannot say this is consideration or this is object. Both will be same. At one point of time, you cannot say this is offer and this is acceptance and this is consideration. No, everything are same. Okay. So it should not be illegal, immoral, or opposed to public policy. Let me go for A. X, who took Y scooter for 5,000. He's actually renting a bike. Engages Z to kill Y. Okay. Who are the two parties? X, who took Y scooter for 5,000. The two parties are X and Y. X is engaging Z to kill Y. and promises him to pay 1,000 rupees to get rid of the payment of 5,000. Engages to kill itself is a crime. So consideration may be there, but it's not lawful. So it is illegal. So 8 points say these 8 points to be present for a consideration to be a valid one. It looks like just 8 points, but if you just go inside the content, you will find here itself. See the second point. See the second point. It's not just one single point, right? We have like some subdivisions. See, this third point is not one single point. It looks like 8 points, but in between the points, we have another extra additional points. Can you just go through them here, please? No consideration, no contract. Okay, this is the general law. When we say consideration is the sign and symbol of every contract, we are very strong with this phrase. No consideration, no contract. So this is a normal example. But there are some exception cases. Even though there is no consideration, there is a contract valid. You can please make a note of this line if you want to. Even though there is no consideration, there is no consideration. If I'm wrong with the spelling, don't consider all the spellings right. Even though there is no consideration, contract is valid. Contract is valid. This is what the exception case means. What is the general law? No consideration, no contract. But what the exception case is? Even though there is no consideration, contract is valid. Let me go for the very first heading, example. Let me go for the example, then I'll go for the content. X promised to pay the debts of his brother Y on account of love and affection. The agreement was put to writing and registered, and law says is a valid contract. Who are the two parties in this contract here? Who are the two parties in this contract? Please don't answer immediately. Check the law and tell. Check the case law and tell. Who are the two parties in this contract? Who are the two parties in the contract? No, no. My case is X and Y. I'm talking about this example. Rajuki versus Bhutan is a case name. I'm discussing the example. No, X and Y not are two parties. I'm asking who are the two parties of the contract. Y and sorry? Y and Z. There is any other person Z? No, there is no Z here. Huh? See, X and Y are the two parties. They are not two parties of the contract. Anyway, a good intro. X and Y are two parties, but they are not two parties to the contract. Here, who has borrowed the loan? Y has borrowed some loan. Okay, so there is a debtor and creditor relationship between Y and another person. So let me keep this another person as Z. Okay, let me go in your angle. Let me keep this another person as Z because I don't know who is Z. Actually, when there is a loan, okay, this Z may be a bank or any person. When there is a loan, there will be a term mentioning that this amount has to be repaid along with this interest within this due date, etc., etc. Okay. The repayment date has come, but Y has not repaid. What immediately X does is, X is promising to Z, even though Z is not mentioned, there is one person who has given the loan, right? X is promising to Z that he will pay Y's debt. Okay. When we say even though there is no contract, even though there is no consideration, the contract is valid, there should be one contract earlier happened. What contract has happened earlier? The contract between Y and Z. X is no party here. See, who's X here? Stranger. X is no party here. There was a contract between Y and Z, and this is about a loan agreement. Okay, this contract is on loan. Is because Y cannot pay the amount, X is now taking the responsibility, which means X is promising to pay for Z. This is the case, you understood? Now there is a one contract between whom and whom here. Z will get something. What about X? Is X getting something? What do you mean by consideration? If I give something, I have to get something. What is X getting? Even though X is not getting anything, law says it's a valid contract. What is the line? Exception line. Even though there is no consideration, contract is valid. Even though there is no consideration for X, the contract between X and Z is valid. Okay? But in addition to that, law also says It should not be just oral. It should be written, and not only written, it should be registered. For whom I am paying the debt? The parties, X and Y here, brothers, right? Siblings. The two parties, between the two parties, there should be natural love and affection. Instead of Y, brother, if I have a friend, I will be having natural love and affection, but it will not be a near relation. There should be some type of relationship. Okay. If these three conditions happen, then X, even though not getting consideration, the contract between X and Z still is valid as per the Indian Contract Act. You get my point? Is it okay? If you cannot accept this, don't think logically, it's act. Okay. Let me go for the second one. Shall I take over? B. A finds B's purse and gives to him. B promises to give A 100 rupees. Is there any offer? No. He finds B's purse and is just handing over to him. Because he has voluntarily done something, now what B does? Promises that he is going to give 100 rupees. It can be a promise to compensate wholly or in part. For what? For something done voluntarily. It's not an order, it's not an offer. Please remember, offer means something I'm promising. It should not be of that type. It should be something done voluntarily. Okay, you say this as a consideration, no consideration, but it's still valid. Shall I go for the third one? Hope the first and second are right. Okay. I want to go for the third one. Third one is a unique case. You can place a star mark because we are going to refer another act. We are not going to talk contract act here. We're going to go and refer another act. What is limitation act? Just remember, there are two parties, Y and X. X has given a loan of 2 lakhs to, sorry, Y has given a loan of 2 lakhs to X. Okay, please just visualize the case. How much the loan is given? 2 lakh or 2 lakh, I'll keep it as 1 lakh. I think in the example, it will be 1 lakh. Y has given a loan of 1 lakh to X. So obviously it is a loan. It has to be repaid within the due date along with interest or whatever it is. This is a usual case. The due date has arrived, but X did not pay it. It's a breach. Okay. When there is a legal agreement, when there is no fulfillment of promise, what the other party Y can do? He can go to the court of law for filing a case. Okay. There is an act called as Limitation Act. This act says, even though it is your right, there is a limitation period for filing a case on X. Okay. If you go and refer the Bar Act of Limitation Act, there is a schedule attached mentioning for this type of a debt, 30 days is a validity period where you can file a case. If it is a mortgage related loan, so what do you mean by mortgage? You attach a property and get the loan, right? Mortgage, pledge, and so many things. Mortgage is something associated with immovable property. Pledge is associated with movable. Immovable means we talk about the term mortgage. If it is a mortgage case, sometimes the validity period, that is the limited period where it can file the suit is for 30 years and more. Okay, if you refer the schedule of Limitation Act, not Indian Contract Act, Limitation Act, it says within 30 days only you can file the case on the other party. Or in some cases it is 45 days, in some cases it is 90 days, some cases 10 years, some cases 2 years, goes on. It depends. The schedule almost goes like some 10 to 12 pages. The act is totally 20 pages, means it will be roughly like 16 or 18 pages. The act 12 or 13 pages completely the schedule only. Only 1.5 to 2 pages about the act intro. So it's saying, what this act is saying is, see, it's your money only. We understand. It's your money only. But when you take this right, see, this right has come to you because you have entered into a contract, right? What this act says is, you can execute this right, even though this is your money, you can execute this right when? Within this period mentioned in the Limitation Act. Okay. Now, X has not given the loan. For convenience sake, this has to be executed. What? The right has to be executed within 30 days. This 30 days is over. See, how many of you know about this Content Limitation Act? We are all laymen, right? How will you know? We try to understand. If you are given a loan to somebody else, how will you know that within 30 days you had to raise a case on? You'll be thinking whether you can file a case or what. You will be in that dilemma itself. And when you come for a conclusion whether to raise a case or not, the 30 days period is over. What the law says here, we cannot accept a case because the limitation period is over. Now, this debt is what you call as debt barred by, what's the line there? Debt barred by Limitation Act. You have to underline this sentence. Debt barred by Limitation Act. Or you can use saying it's a time barred debt. What do you call this as? Time barred debt. Which means the same, okay? Which means the same. It means your right cannot be executed. What is your right? Right to file a suit cannot be executed. Can please make a note of this one. Cannot be executed. Is it okay, Bob? Cannot be executed. Right to file a suit cannot be executed. Okay, yeah. Now what happens is suddenly on one day I meet you, I meet X. Okay, X says to buy. Ma'am, on the other day I borrowed loan 1 lakh from you. I did not repay. But definitely, ma'am, I'll repay at least 95,000, ma'am. Which means what? You're promising for 95,000. But originally the contract for 1 lakh, but you're promising for 95,000. What I will say? No, no, ma'am, that's okay. You keep it. I'll say this one or இவங்கிட்ட இருந்து வராதுன்னு நினைச்சோம் இன்னும் நல்ல டைம் போல இருக்கு. So automatically I say okay, right? See, not only myself, any person over there, what they'll think, okay, it's the my money, I'm getting it. Let me go for the promise. See, he's not paying immediately. He's just giving a promise. What X is doing? I will pay 95,000. Then why is getting some benefits? What X is getting? Because there was an original contract and that contract cannot be executed, that right cannot be executed. From that one, this is not arising. And even though there is no consideration for X in this contract, the contract is valid even though there is no consideration for X. Please try to understand this angle. Already there was one contract between X and Y where Y gave the loan to X for 1 lakh rupees. Etc. Everything happened, but it became time bound. Now X is promising that I will pay not 1 lakh, but 95,000 or 5,000 or 10,000, whatever the amount is. Now this becomes a contract valid even though X is not getting any consideration. Why is getting benefits because of this contract? X is getting benefits? No. Okay. Now come here. Paying a time bar debt, but it should be returned and signed above. It should be returned and signed. Oral will not be accepted. It is returned, not signed, not accepted. See, earlier this one, the first point, I don't know how far you notice. It's written and registered. It should be written and should be registered. Okay, registered means what? You need to have a stamp duty. You need to go to the register office and register in the record. It will come in the encumbrance case. But what happens here is enough that is written and signed need not be registered. Okay. Who has to written and signed? By the debtor or the agent. Fourth one, law of agency. Actually, I cannot discuss more about this point 4, 7 and 8. You can please make some notings because when I go for discussing special contracts, I'll discuss over there. It's all dealing with special contracts. Law of agency between principal and agent, yes, even though there is no consideration, contract is valid. Contract of guarantee, consideration sufficient. I'll discuss this not now, later period. Gratuitous payment. In these three cases, even though there is no consideration, contract is valid. Okay, I'll stop here. Let me go for the fifth one. Shall I take over? Let me go for the fifth one. A completed gift, even though there is no consideration, is a valid contract. See, I'm not talking about gift. What do you mean by gift? I am gifting my son a watch. Okay. I am gifting my dad a what a muffet. That is means what a bike. This all happened cases. This is gifting. This and all comes under social agreement, right? Because I'm not getting anything in return. I'm gifting my student because scored a rank holder. I'm gifting 10,000 rupees. It's all gifting. Okay. So who is ready to get 10,000? Obviously, it's not a promise, it's a gift only. Okay. See, these are all gift. But we are using the term called as, yes, can you just say that word to me? What term I'm using here? Before the term gift, what I'm using there? Please refer and tell me. What is the term over there? Completed gift. Okay. When we say completed gift, example donation, there's an orphanage. Okay. Every month, each and every month, I pay 1,000 rupees to the orphanage and they'll give a receipt. They give a bill like to me. Okay. When they give a receipt, actually they are giving a promise that they'll use this 1,000 rupees for a specific case. Which means, even though it's a gift, there is a reason for this gift. See, you may say that there is a reason for giving a watch to a son or giving a automobile to a dad or 10,000 rupees to the student. There is also a reason, but this reason is becoming legal because you're giving a receipt. And there's a reason behind. You're giving for whom? Not your son or your dad or any close friend or relative. You're giving to some person totally not out of your radius, orphanage, or giving some amount for temple renovation work, church renovation work, or giving some amount where, see, during this Vinayak Chaturthi and other festival, they'll be having this roadside statues and all, right? You're giving for that payment. If you're giving for that purpose, then you can or you have the right to ask, what is this 1,000 rupees spent for? It becomes a consideration. Even though there is no consideration for your side, they are getting some benefits, and that benefits is enough for your satisfaction, and it's called as a contract. But what it should be? Completed gift. You are paying for some flood relief fund or natural calamity fund. All these falls under completed gift. So completed gift can be equated with the word donation. Okay. And another one line will be there with respect to transfer of property. Okay. Transfer of property. You have your grandma or grandpa. Okay. And after their life, their property will be settled to you. That's law, legal hire. You'll be the legal hire. The property will be settled to you. Okay. But your grandma or grandpa are alive, and what they are doing is during their lifetime, they are gifting the property in your name. Okay, they're gifting the property in your name. Are you going to pay 1 rupee or 2 rupee or 10 lakhs or 1 crore? No, because it's a gift. Even though it comes out of love and affection, what transfer of property act says is, see, we are not talking about legal consideration. We are talking about lawful consideration. We have to go and refer because I'm talking about a property. Property means it's not covered under Indian contract, it's covered under Transfer of Property Act. What Transfer of Property Act says is, even though there is no single penny amount received from the transferee, the contract is valid. The sale is valid. It is a gift. You might be knowing in those days all the kings and all the jamindaris system are there. All the jamindars will be donating the land to the temple, church, and other places for social gatherings and for social commitments. They will be donating. All these are considered as completed gift. Okay, but it should be if when we go for transfer of property act, it should be related to immovable. No? Is it okay? So that's about this point. And sixth one, very beautiful one, remission. Let me go for the example. Y gave a loan to X 1 lakh. It's a due date that you have to pay the payment. Today is the due date. Just imagine. X is approaching Y saying that, ma'am, you gave me 1 lakh, but today is the due date. I have only 95,000 in my hand. Please accept. Okay. See, if I am not accepting it, I can go to the court of law. See, limitation period is all there. That's different. I can go to the court of law. But what I'm doing is I'm accepting your amount, which means I'm not going to expect the remainder. It's lesser fulfillment. What was the amount engaged in the contract? 1 lakh. How much you're paying? Even 1,000 rupees less is also less only, right? If it is 1 lakh plus interest, means 1 lakh plus interest should be there. If it is even 100 rupees lesser or 1,000 rupees lesser or only 50% you're gaining, or from this 1 lakh, X comes and says to Y, I can pay only 10,000, I have only 10,000 in the hand. And you almost now, he's almost bankrupt. What do you think? Wow, 10,000 on the day போகும் கண்ணில் ஒத்தி வச்சுப்பீங்க வராது நினைச்சீங்க right? So this 10,000 itself is sufficient, means even though it's a lesser fulfillment, the term used for lesser fulfillment is remission. You remember we were using revocation, rescission. Okay, this is remission. Remission is lesser fulfillment. But you have to understand that you cannot ask for the remaining because it's lesser but fulfilled. Please understand it's lesser but fulfilled. So that's about the sixth point. Two more points. Contribution to charity. Obviously, you can refer this Gori Mogammed case. And tenth one is a beautiful point. Contract under seal. If there is a contract where under the law, which law? Directly I'll go for Companies Act. Companies Act says you can have a common seal is not mandatory, but still if it is not mandatory, you can have another two directors to have a common seal for authenticating of records. If a common seal is affixed, and even though is there in any mistake, it becomes valid even though it is without consideration. So deed with under seal will be considered valid even though it's made without consideration. To more support this case, this heading, let me go for an example. We can just turn over to this third practical problem under page number 2.21. Can you go for this third problem? Go for the third problem. This is a case happened in Higgins Limited versus Northampton Corporation Limited. These both are companies. When we say about companies, it's about, we are talking about artificial person. Am I right, Pa? When we say company, we are talking about artificial person. So who's leading the business? Board of directors, they are the human agency, so they have the complete right. But law says you need to have a common seal. Even though it's not mandatory, you need to have a seal. If there is no seal, it should be signed by two directors or director and company secretary. This is the law. Okay, you need not get overloaded. This is the law falling from Companies Act. Here, H contracted, who's H? Higgins. Higgins Limited contracted that's another person. Who's another person? H, again a company. What was the contract about? Demolition of number of houses. In calculating the price for the houses, H by mistake deducted a particular sum twice. They need to show some workings and calculations, but made some mistakes, maybe typo error or human error. Instead of deducting once, what they did, they deducted twice. The corporation, even though it's by mistake, the corporation affixed a seal. Once the seal is affixed, it says it's correctly representing his intention. Now is the contract binding? Access, yes. Even though there is no consideration for one house, probably let me go for I'm erecting 500 houses. Okay, I need to do some calculations, and this is for 1 lakh per house. So what's the calculation? 500 lakhs I have to raise in the invoice. But by mistake, I did some wrong calculations. I just made it's 499 lakhs, which means the intention to erect the 500 house cost 499 lakhs, and it's like, yes, you're right. Because I have sealed, which means I have affixed the seal. This is not falling from Indian Contract Act. Please remember, we are following lawful considerations. So we are not sticking to Indian Contract Act. We have to stick to other acts also. So when you refer the other Corporation Act, like Companies Act and all, it says once the seal is affixed, yes, it's over. It is clearly expressing its intention. And the law says the contract is binding. Okay. So you need to have all these 10 points noted. So how many exception cases are there, Pa? 10 cases, which means under these 10 cases, even though there is no contract, the contract is, even though there is no consideration, the contract is valid. Can you please go through till here? Just go through the 10 cases. If that's okay, na, then you go for this fourth case. Problem number 4. Here R is a manufacturer of light bulbs. He advertises in the trade press that in future, the retail price of his bulbs will be 4 rupees. Okay, which means below 4 rupees you should not sell. And that the proceedings will be taken against any dealer who's not observing this price. If anybody is selling below 4 rupees, then R will file a case on those respective person. Okay. You remember I was telling you if you have to understand a case law, read once first completely, then go for breaking into two headings. You just stop over here. Okay. Usually, when a question is asked, the main intention is to confuse you, to check whether how far you're strong with the concepts. Here, T buys a quantity of the bulbs from X, a wholesaler. Although T had originally read the advertisement, He forgot its content and retails the bulbs at how much par? Above 4 rupees. You advise R. So if you are a consultant for our company, if you are a chartered accountant or CMA, probably if you are a CFO, Chief Financial Officer, you are in the advisory capacity of the company, what you're going to advise are, sir, this tea did not follow our rules. He's selling for 4 rupees and 25 paise. Immediately file a case, sir. Are you going to say this? We are all law students now. You should not deal this way. Now check this is what is happening. Please remember when there is a contract, you have to check who are the two parties. Even though you are a successful chartered accountant or cost accountant, please remember you have to check all the essentials of a contract act. For a contract to be a valid one, we have minimum two parties, etc., right? Also check who are the two parties and who is the third party. Who are the parties here? Who are the names mentioned here? One person is R, one person is T, and another person is X. Who's this R? Manufacturer. Who's this X? Wholesaler of bulbs. Okay. Who's this T? Nothing is mentioned, but I'm going to buy some two bulbs of Singer Academy. I'll go to the wholesaler and buy for two bulbs. Where I'll go? I'll go for a roadside shop and buy two bulbs and come. And it's all available in supermarkets. I'll go for buying rice. I'll go for buying pulp. I'll go for buying sugar. Along with that, I'll buy two bulbs and come. This is what happening in Singer Academy, right? Okay. I'm not going to go to a wholesaler and buy two bulbs. No. So who's going to be this team? He's going to be a retailer. Okay. What's this advertisement or what this is not an advertisement, it's a trade press information. What is about? Are saying that it should not be sold below 4 rupees. If sold, proceedings will be taken off. Now, we have to check who are the two parties in the contract, how many contracts are here, and who is the third party of the contract. How many contracts are here, first of all? One contract, X should have bought from R. Am I right? Who's X here? Wholesaler. So he might have bought from, he's not manufacturing. He might have bought from R. R is the manufacturer. So there is one contract existing before R and X. Is it okay? And what is this role of T? T is the retailer. He buys from X. So there is another one contract existing between X and T. When you talk about this contract, there is no role for T to be played, and when you refer this contract, there is no role for R to be played because they are third party. General law says stranger to a party cannot sue. Now, who is selling for 4 rupees, above 4 rupees? T is selling for 4 rupees. That is, it's selling for 4 rupees and 25 paise, right? It's selling above 4 rupees. And there is no contract for R here. There is no role to be played for R here. So R becomes a stranger to a contract. So general law says we cannot sue. Okay. So if you are the advisor for the company, you should just think in this angle. You should not think towards or in favor of R always. You have to check who are the two parties. Okay. Probably, who knows, you'll be referring all the bar act and you may be giving a call. Ma'am, R is here, ma'am. What can I do? I'm working for R. And this R is giving 2 lakh salary, ma'am, for 1 month. What I can do? If I win this case, ma'am, definitely I'll get a promotion. Not only promotion, I'll get a hike in salary also. And not only that, they'll be giving you a BMW car. So your mind fully will be working on how R can file a case. How R can file a case. See, the concept is not R filing the case. The concept is who is R to file a case. R is who here? Third party. How can he file the case? Okay. So you'll not make to call me, right? You're not going to call me, right? Sure. சிஏசிஎம் பிறகு திட்டு வாங்காதீங்க என்கிட்ட என்ன படிச்ச கான்ட்ராக்ட் ஆக்ட் முதல்ல ஃபவுண்டேஷன் கிளாஸ் பாரு. See, who are the two parties in this contract? X and T. And when we say R, here R becomes the third party. So third party is generally a stranger, cannot sue. General law, okay? Actually, when you refer this case, actually instead of light bulbs, we are referring light bulbs, right? Actually, the case happened was tires. Can you find the case law below there? Dunlop Tires versus Selfridge Company. The case happened between Dunlop Tires and Selfridge Company. I request you to go through this case. Instead of light bulbs, it will be Ditto Tires. There will be one intermediary X, who's Dunlop R. Who's Tyres? Selfridge. Okay. Sorry. Who's T? Selfridge. Who's the main person to the contract? X. X is, I think, Duve and Co. Some company, Duve and Co. Okay. Not sure with the terms. Not. I couldn't remember the exact wordings and all, names and all. You can just go and refer. It's a beautiful case. So this is a landmark case which says a stranger to a contract cannot sue. This is a general law. Now, what are the specific categories lying over here? Okay. So you call this doctrine called as privity of contract. In a Dunlop case, who are the two parties? X and T. There is a privity of contract between X and T only. There is no privity of contract when we go for R. We cannot talk about R. R is a third party. So this is a doctrine called as doctrine of privity of contract. Let me go with the exception case. First one. This is a case Dan Kubar versus Sarla Devi case. What is this case is about is actually there is a Hindu father. Okay, not religion based and all, but the case is religion based. Okay, there's a Hindu father and he's no more. When you go for the Hindu law and when we go for the legal hires of this deceased person, first stands the spouse. Spouse means husband, wife. Husband has passed away. Who stands first? Wife. Wife passed away. Husband stands on the first in the list. Then son, daughters. Now daughters are also equal right are given. Then comes mother of the deceased. Then father of the deceased. This is the usual order. In this case, there is no mother and father, which means what? They have already passed away. So how many are here? Spouse. Okay. And only no daughters, only sons. And how many sons? Please, three sons. Let me name them as son 1, son 2, and son 3. Usually, what the Hindu law says is if there is a combined, there is a half Hindu family, and if they want to separate in the future, they can divide all the property between them, and they can get separated. They can take over the business. So these three sons plan in such a way they divide their property. Actually, between four it has to be divided. Am I right? Because mother is also there. But they themselves come for a mutual understanding. The property will be divided by these three sons, and a monthly maintenance will be given towards her mother. How much is given? That's a small operational thing done here. They will invest each, I think, 10,000. So 10,000, 10,000, and 10,000 in a bank account. Okay. 10,000 will be deposited by S1, again 10,000 by S2, again S3 will be depositing 10,000. So each and every month, 30,000 will be deposited, and this 30,000 is not for the mother's monthly maintenance. This 30,000 is for in case they face any issues with the house, any problem with the house, they want to renovate the house, the property, then this amount will be used. But when you go for opening an account in the bank, the bank will be fetching some interest, right? This interest amount will be given as the monthly maintenance to the mother. Every month it will go directly from the bank, not to son 1 or son 2 or son 3. That's a mutual understanding between the bank and the sons. Who are the two parties here? Two parties means not exactly two parties. One side of the party is bank, other side of the party is whose mother here? Stranger to a contract, but she has this whole category called as beneficiary. So she being a beneficiary in this contract, she can file a case. Okay. So this is about the contract here is. So the nature of that person should be a beneficiary and some trust or change should be created in some specific immovable property. Please highlight. Why we mean this as specific means because law to law it is differing, right? I'm talking about Hindu law, it's okay. But law to law it differs. So it should be specific immovable property only. So this is first point. Let me take over the second point. Shall I join? Marriage settlement. Again, if there are male and female members in the family, female members' family expenses, maintenance expenses, all should be taken by the male members of the family. Usually, when we talk about Hindu undivided family, Karta. If the Karta passes away, the eldest son will become the Karta. So this is the concept. So maintenance, marriage expenses of the female members before partition, or it will come as per the family arrangement. Third one, let me go for the example. A pays B 500 and B acknowledges to C that he holds for him. Please try to understand. A pays B 500. Who are the two parties? A and B. And B says to C, I am holding this amount on behalf of you. So the two parties are not A and B. Who are the two parties here? A and C. See, the first and foremost thing you have to identify the two parties for. Who are the two parties here? A and C. But to whom A is giving the money? To B. But this is not B's amount. On behalf of C, he is holding the amount. Here, even though C has not got the amount, C has a right to enforce, which means an acknowledgement is created or an estoppel is created. Actually, I want to go outside. I want to have a 5 minutes break. I want to make some small payment. I need 5 rupees cash. Anyone have? I'm not asking, I'm giving an example. Immediately, you just search your purse. You're not having this 500, but the person beside you, he takes his wallet, he takes his pouch, and he says, I have 500. But he's not giving directly, he's giving through your friend. Okay. So, it is whose money? A's money or B's money or X money or Z money? Right? Now, in case there are two persons sitting beside, okay, actually this person is taking his pouch, but he is not giving directly to me. He is giving through himself because, see, I am in this tension. I need 500 rupees. I'm not in the classroom. I'm outside the classroom. I don't know what is happening inside the class. Immediately, this person A, this person comes and gives to me, ma'am, have this 500. What I will think, this is A's money. But whose money is this? Okay, so ultimately, C has the complete right. You call this as estoppel. What I think is it is taken from, I have taken from A only. This is what you call as estoppel because as for, see, just take my point of view. I don't know what is happening. What I think, it is A's money only. It's creating estoppel. Estoppel means depending on the circumstances, it's created in such a way. What this B person has to tell me, ma'am, I give this 500, ma'am. Or at least when A is giving, B has to communicate or B has to come along with A to give the money. But nothing is happening with B. So what is happening here? I'm thinking just only A is giving. So A becomes the party like. So it's called as estoppel. The circumstance is created in such a way. It's made to believe because it's not happening in my knowledge. Okay, so promisor constitutes himself as agent. Who's A here? Agent of B. That's the third one. Fourth one, assignee of rights and benefits not involving personal skill. See, if it is a painting work, if it is a singing work, some live concerts are going. I'm asking some musicians or artists, playback singers to perform. Then it's of personal skill. Okay. If there is a construction expo going, what do you mean by construction expo? All the building contractors will come and they'll explain their project, etc., etc. So this construction expo is going. If one employee is absent, another employee will come and perform. Yes, no issue. Okay, so if it's not of personal skill, yes, you can assign the rights and benefits. That has been stranger to a contract can sue. Fifth one, I'm not discussing now because agency contract, go and refer the special contracts law of agency. Sixth one is a beautiful point. Let me go for the example. A gives the property to his son-in-law on his marriage with daughter. Please try to understand. A is gifting to, so there are two persons, X and Y, who are going to get married. Okay. So they got married or something like that. Who's A? Y's father. Y is the girl. So girl's father gifting his son-in-law what? This some property. Okay. Who are the parties to the contract? X and Y or A and Sil? Sil means son-in-law. Okay, son-in-law. Short form. Sil, mil, dil, daughter-in-law, dad-in-law, that is father-in-law, Phil. It's so boring to write son-in-law. That's why I don't see. So, who are the two parties to the contract? Okay. A gives the property to his son-in-law on his marriage with daughter. Now, whose property is this? Sil's property. A gets the right to enforce his rights, which A has already had. In case, why A is gifting his property not to his daughter but to his son-in-law? Though you should not think this logically, but this is the background happening, right? He's gifting his son his own property, not in the name of his daughter. In his son-in-law, he's gifting, which means what? He wants to give a protection to her daughter, right? But in case if the sill is selling the property or damaging or utilizing in a wrong way, even though A is not involved here, A has already gifted the property, right? Even though A has no right here, but already he had this right, and because of this arrangement only, he gave this right to sill. So he has the right to enforce. See, covenants. Covenants means some conditions, encumbrances. If it is running with the land, see, remember it should be land only. It should not be a car or something like that. Land which may be enforced by the successor of the seller. Who's the successor? Who's the successor? A is the successor. Who's the seller? Who's selling? Still. Who's the successor? Okay. What's the relationship? Okay. See, actually, the logic behind this, there should be immovable, especially land. Okay. Land property. Okay. See, if you're buying a property, you'll take all the mother documents. You might be knowing all the income, Thai Patram, mother document, all the income process related, EC will be taken, everything will be checked because they need to know who is the successor, what was the state when he was transferring the property. And all. So this is the sixth point. Next, oh, that's it. Only 6 points. So there are six exceptions which says that stranger to a contract can sue. Okay. So that's about consideration. Practical problems. Any doubts still here? Can you just have a fast glance? Fourth one we have done, third one we have done. Shall I go for the second one and before you wind up? Yeah, please. A Muhammadan lady said there's a description given, which means we are following Muslim law here. Okay. A Muhammadan lady sued her father-in-law to recover arrears of allowance payable to her by him under an agreement between him and her own father in consideration of her marriage. Will she succeed? This was happened. This is a happened case. If possible, you can refer this case also. What is actually happening is A, she is a Mohammedan lady. She's about to get married. Obviously, she needs to take care of her family, but before she's getting married, what she's doing is she is having an agreement with her father-in-law. See, father-in-law. See, what was the agreement? What was the agreement? A's father, right? He's somewhat aged person or something like that, and she needs to take care. So once I get married, you have to give some monthly maintenance to her father. Let me come again the case. A Mohammedan lady sued her father-in-law to recover what? Arrears of allowance payable to her by him. By whom? By Phil. Because of an agreement entered between him and her own father. Okay, so probably not the contract between here. Oh, sorry, father-in-law. Okay, in consideration of a marriage. So once I get married to your son. Okay, so this is whose lines? A's lines. Once I get married to your son, you have to give the payment, monthly maintenance to my father. And this was not paid, and she sues for recovering the arrears of allowance. Is this a valid one? If you go for referring to the general cases of contract, what's a contract? Validity of a contract, essentials. If the relationship is about family arrangement, the contract cannot be executed, right? But this is about Muslim law, where it says, I don't know how far the Muslim law is right. I'm not much aware of the Muslim law. But here, being the description, Muhammadan lady, the contract is entered between whom and whom? Father and father-in-law. Okay. But who's A here? She's a beneficiary because she has to support her father. So she's filing a case. Yes, A being a stranger to a contract, she can sue. Okay. Can you please refer this case, pa? So I think first one you can manage, fifth one you can manage, and sixth also you can manage. Okay. So that's about consideration. Next class we'll discuss on capacity of the parties. Thank you.